Carlos gets into a heated argument outside a bar in San Jose. He doesn't throw a punch, he doesn't make contact, but he does raise his fist and steps forward. 2 days later, he gets a call from a detective. He's been charged with assault. If you're facing assault or battery charges in California, these are two separate crimes, and one of them requires zero physical contact. I'm Nana Knight. I'm a criminal defense attorney in San Jose, California, and in this video, I will break down what each charge actually means, when they escalate, and what defenses actually work. People use the words assault and battery interchangeably all the time. In casual conversations, that makes sense. However, under California law, there are two distinct crimes with different elements and different consequences. Let me start with the definitions because they do matter. Assault under Penal Code Section 240 is an unlawful attempt coupled with a present ability to commit a violent injury on another person. And the key phrase here is present ability. No contact is required. You do not have to touch anyone to be charged with assault in California. What the prosecution needs to prove is that you intentionally acted in a way that would directly and probably result in the application of force to another person. The prosecution must also prove that when you acted, you had the present ability to carry it out. The bar here is lower than most people expect. Now, battery under Penal Code Section 242 requires actual physical contact. The definition is any willful and unlawful use of force or violence on another person. The force does not have to cause injury. A shove, a slap, grabbing someone's arm, touching someone even through their clothing, these can all qualify as battery in California. And what matters here is that the contact was willful and done in an offensive or harmful way without the other person's consent. So to be clear on the difference between assault and battery. Assault is the threat or attempt, whereas battery is the follow-through. You can be charged with one without the other, and in many cases, you could be charged with both simultaneously. Now let's talk about the penalties for simple assault and battery. Simple assault under Penal Code Section 240 is a misdemeanor in California. The penalty is up to 6 months in county jail and a fine of up to $1,000. Simple battery under Penal Code Section 242 is also a misdemeanor. The penalty is up to 6 months in county jail and a fine of up to $2,000. These are the base penalties for the most straightforward versions of these charges. They escalate quickly, however, based on several factors. When charges escalate, things get complicated. The escalation path depends on three factors: what was used, how serious the injury was, and who the victim was, as in the victim's status, right? There's some protected categories of victims where the law anticipates enhanced penalties. First, weapons and deadly force. Under Penal Code Section 245, assault with a deadly weapon is a wobbler, meaning that a prosecutor can charge it as a misdemeanor or as a felony. And that depends on the facts. It depends on the aggravators. As a felony, the sentence range is 2, 3, or up to 4 years in state prison. A deadly weapon can be an obvious choice like a knife or a gun, but courts have also found that cars, baseball bats, simple objects like a stick, and even other types of hard objects like bottles qualify for assault charges with a deadly weapon. The key is whether the item used in the way it was used under those circumstances was capable of producing death or great bodily injury. Second, great bodily injury. If an assault results in great bodily injury, meaning a significant or substantial physical injury, an additional enhancement under Penal Code Section 12022.7 can add 3 to 6 additional years to any base sentence. So for battery, if the contact causes serious bodily injury, the charge becomes aggravated or serious battery under Penal Code Section 243D, which is also a wobbler. As a felony, the sentencing triad for Penal Code Section 243D is 2, 3, or 4 years, and that's state prison. Third, let's talk about the protected class of certain kinds of victims. So California law imposes enhanced penalties when the victim belongs to a protected category. Assault or battery against a peace officer, a firefighter, emergency medical technician, or a healthcare worker, teacher, or transit worker can all result in increased penalties under specific enhancement statutes. Battery on a police officer under Penal Code Section 243B and C carries penalties up to 3 years in state prison as a felony. Battery on a school employee under Penal Code Section 243.6 carries a separate penalty structure as well. The point is that what looks like a simple misdemeanor on the surface can carry significant sentencing exposure once the facts of who was involved and how severe the harm was come into play. Now let's talk about common defenses. This is the part of the conversation I want most people to hear because I have seen cases where charges were filed and people just assumed the outcome was predetermined. It is not. Defense number 1. Self-defense or defense of others. California law recognizes the right to use reasonable force to protect yourself or another person from imminent harm. The key requirements are that you reasonably believed you or someone else was in imminent danger of being touched unlawfully or suffering bodily injury. And also that you reasonably believed that force was necessary to prevent that harm and that you used no more force than was reasonably necessary under the circumstances. A reasonable belief does not have to be correct. If you genuinely believed you were about to be attacked, even if you made a mistake in that belief, and a reasonable person in your situation would have shared that belief, that defense still applies. What you cannot do is use more force than the situation called for. And you generally cannot be the initial aggressor and then claim self-defense when the other person responds. Defense number 2, lack of intent. Both assault and battery require willful action. An accident is not a crime under these statutes. If you were gesturing during an argument and accidentally made contact, or if you bumped into someone in a crowd without any intent to do so offensively, the willfulness element is not met. The defense requires careful analysis of the specific facts and often depends on witness accounts and the physical evidence about what actually happened in that situation. Let's talk about defense number 3, mutual combat and consent. California law has a complicated relationship with this idea of mutual combat, but mutual combat can be a complete defense to assault charges. So for example, if 2 people voluntarily agree to fight each other, that consent can negate a battery claim. But the consent defense does have limits. Courts will not apply it in situations involving significant force imbalances, such as when weapons are used or in circumstances where the fight escalated beyond what was agreed upon. If the altercation began as a mutual fight and then one party pulled a weapon, the consent defense could evaporate. Defense 4, insufficient evidence. Prosecution requires proof beyond a reasonable doubt of all the elements of whatever crimes you are charged with, right? So assault charges in particular often rest on one person's account of what they believed what was about to happen. If the prosecution cannot establish the elements of presentability and the intent to cause harmful contact, the charge does not hold. In cases that come down to one person's word against another's without corroborating physical evidence, the defense has real room to work with. There's some flexibility there. Now let's talk about domestic violence battery and why this is different. I want to spend some time on this because people charged with domestic battery often underestimate how different the consequences are compared to a standard battery charge or a standard assault charge. Domestic battery under Penal Code Section 243E1 applies in situations when the alleged victim is the current or former spouse, cohabitant, fiance, co-parent, or someone you are or were at some point in a dating relationship with. The physical conduct that would otherwise be simple battery under Penal Code Section 242 now becomes a different charge when there's that special relationship. The penalties on paper look similar. Penal Code Section 243E is a misdemeanor. It carries up to 1 year in county jail and a fine of up to $2,000. But the real consequences go far beyond the criminal penalties. First, a criminal protective order is almost always issued at arraignment in a domestic battery case. That order can prohibit you from returning to your own house, contacting your kids, or communicating with the other party. Violating that order is a separate criminal offense, typically as a misdemeanor, under Penal Code Section 273.6. Second, a domestic battery conviction typically requires the completion of a batterer's intervention program. Could be anywhere from 16 weeks to 52 weeks. Third, under federal law, the Lautenberg Amendment to the Gun Control Act prohibits anyone convicted of a misdemeanor domestic violence offense from possessing firearms. This is federal law. It applies regardless of California's classification of the offense as a misdemeanor. If you're a gun owner, this consequence alone is significant. It is also significant consequence for military members. If you're in the military, whether you're in the reserves or on active duty, even a misdemeanor conviction for domestic violence disqualifies you from possessing, carrying weapons. You are then subject to involuntary discharge from the military. Fourth, domestic battery can affect family law proceedings. If there is a custody dispute or a dissolution case pending concurrently with your criminal case or your arrest, a domestic battery conviction can change the outcome of those proceedings substantially. In California, it can make you presumptively ineligible for custody of your own children. Fifth, immigration consequences for non-citizens can be serious. A domestic battery conviction may be classified as a crime of moral turpitude under federal immigration law, which is a deportable offense for non-citizens. Restraining order implications. Even before charges are resolved, a domestic violence restraining order or a civil harassment restraining order can alter your life in immediate and concrete ways. In domestic violence cases, an emergency protective order is often issued at the scene by the responding officer. It takes effect immediately, and it can last up to 7 days. Within that time, the alleged victim can seek a temporary restraining order, which, if granted, can last until a full court evidentiary hearing is held in civil court. At the full hearing, a restraining order can be issued for up to 5 years. In criminal court, a criminal protective order could be issued for up to 10 years, depending on how serious the case is. The civil restraining orders are separate from the criminal protective orders. So even if the criminal charges are dismissed or reduced, the civil restraining order process continues in a different court. If you're named in a restraining order, you need to understand its terms completely and make sure you abide by those terms. Restrained parties are sometimes surprised to find that even brief or accidental contact can lead to a violation. If your restraining order says you cannot have third-party contact, sending a text through a mutual friend violates that term. Showing up at a location where the protected party is known to regularly visit. These can all be seen as violations. So let's talk about what to do if you're charged. The charging decision in assault and battery cases often happens very quickly, and the initial framing of the incident by law enforcement shapes how the prosecution views the case from the beginning. And they're going to look at the police report, they're going to look at all the statements that the police officers collected on the scene, including the statement from the complaining witness. If you're arrested or contacted by police about a potential assault or battery charge, your first call should be to an attorney. Do not try to explain what happened to the responding officers. Do not try to tell your side of the story to the detectives, even though you may be motivated to do so. The instinct to set the record straight or tell your side of the story to get it out there is understandable, but anything you say does become part of the case. Anything you literally say can be used against you, and the details you offer without talking to an attorney first can be used to fill the elements of the charge that the prosecution would otherwise have to prove on their own. Have you or someone you know been charged with assault or battery in California after an altercation where you believed you were acting in self-defense? Drop a comment below with what county the case is in. The facts matter enormously in these cases, and I'm happy to review the comments. I always try to do that, and I may even point you toward the right questions to ask your attorney. So get your case evaluated early. The options available to you at the beginning of a case are almost always broader than the options available to you after months have passed. And if you want to know how to get charges like this dismissed, watch my next video on 3 new ways to get your criminal case dismissed in California. It is on this channel. And if you're facing assault or battery charges in San Jose or anywhere in Santa Clara County, California, call NightLaw at 408-877-6177. Drop a comment below and let us know, was the other person the one who made the first contact, or was it something else entirely? Your facts do matter.